Bags up here and let if you want that.
I'll move to that end then. And then there's a lot less on the screen.
Whenever you.
You have a clicker? Oh, are you gonna come over? Yes. Okay, all right. All right, it is 11, and in the spirit of staying on time and being conscious of everybody's time commitments, we're gonna go ahead and get rolling again for the rest of the morning. So happy to have OMB here to talk about their part of the rulemaking process and overview. Patrick Price, Special and General Counsel, as well as Justin McAdam, the Deputy Director and Chief Legal Counsel. So I'll hand it off to you all.
Well, good morning. For those of you who don't know me, I'm Justin McAdam. I serve as Deputy OMB Director and Chief Legal Counsel for the Office of Management and Budget. So, with OMB, we wear a lot of hats. Obviously, we spend a lot of time on taxes and finances and budgets, but we also spend a lot of time on rules. And, we really sit at sort of the intersection here between agencies, the administration, and stakeholders on the rulemaking process. And so what we want to touch on today are a number of different topics. We'll give you a brief overview of the OMB and SBA review process. We won't cover that in too much depth. I feel like as we talked through it, it seemed like most people have a pretty good handle on that. And we'll have some additional guidance documents that we'll post on our website, maybe a longer presentation that kind of walk through it in a little more depth. But always happy to answer questions on that. Then we'll pivot to a topic on general rulemaking requirements. And really, this is a question about what should be in a rule. The Attorney General's office touched on this topic a little bit. I think we'll pick up on that and dive into that in a little more depth. It's a question that comes up fairly frequently in our discussions with agencies. And so we want to provide a framework for how to think about that, how we think about that, and give a couple examples of how we see that playing out. And then lastly, Patrick will walk us through the cost-benefit analysis process. And here we want to spend a lot of time talking. We want to spend less time talking about sort of the requirements from a legal perspective and talk more about how to prepare and think about cost-benefit analysis, how to use it. And so he'll walk through a sort of a step-by-step process there, laying out for you what our cost-benefit, how we think about the cost-benefit analysis and some of the common issues that we encounter. And then we'll pivot to questions and happy to walk through any questions you have and talk through those here in real time. So the OMB review process, as the Attorney General's office touched on, comes out of a couple places. It's memorialized in part in statute and also originates from Executive Order 13-3, which established what was called the regulatory moratorium. And then is explained in a little more depth in our financial management circulars. These are SBA's internal rules that govern how we interact with agencies. To call it a moratorium is probably not an accurate reflection of where we stand today. We spend a lot less time thinking about whether a rule qualifies for a particular exception, and a lot more time working on looking at the cost-benefit analysis, looking at the impact of the rule, coordinating with the governor's office, and looking at the policy more generally to make sure that it's consistent with where we as an administration want to go in a particular policy area, and really looking at the burdens that those rules place on regulated parties and the benefits that they confer. And our goal is to maximize the benefits conferred while minimizing the costs imposed. And obviously that's an art, not a science. And we recognize that. And we try to spend a lot of time talking with agencies to work through that process where we have concerns or are looking for additional understanding. The SBA review process, so the OMB review process happens before you begin formal rulemaking process, at least as it's currently formulated. So before you file your notice of intent, you're working with us. After you file your notice of intent, Executive Order 2-89 requires you to come back to really the budget agency for sort of final approval of your rule. And in this case, the real focus is just on the fiscal impact analysis that SBA prepares. And they do prepare one on every rule, often reliant heavily on what the information that the agency provides. And from an OMB perspective, all that we're really looking at is to see that the language that we approved in the OMB review process matches the language that we're seeing in the SBA review process. And so to the extent that they're different, we'll ask you about that, and that may lead to some further conversation. But in general, what we see is the language matches because we've already gone through the heavy lifting of the OMB review process. But what does this mean in practice? So I don't know that everyone thinks about it this way, but we try to think about it as a collaborative process between OMB, the governor's office, and the agency. And really the goal is to achieve the policy objectives that the agency is trying to achieve in the least intrusive and most beneficial way possible. We spend a lot of time focusing on the language of the rule, and then the other time spending on the cost-benefit analysis. On the language side, we're spending a lot of time thinking about whether the language is clear, concise, whether the language is consistent with maybe how similar requirements are articulated in other types of rules that we see. We have the benefit of sitting at the intersection of every agency's rules, and so we see the same concept addressed in different contexts, in different ways, in a lot of different places. And so that gives us the benefit of that experience to be able to bring that to bear and provide helpful comments, we think, to other agencies in simplifying or otherwise matching requirements across agencies. And one thing we'll note here at the end, this has only been really challenged one time, but it's important to note that the OMB review process is deliberative. So it's a confidential process if you choose to keep it that way. And there are reasons you may or may not do that, depending on your particular needs and the particular rule that you're dealing with. But there's a PAC opinion from the Public Access Counselor in 2017 that affirms this position, that the documents you submit to us, the proposed rule language, our analysis and our response to you is something that you can keep confidential. And so it helps enable us to have that conversation freely and openly without fear that we'll have to be held accountable for something we haven't really settled on in a final form. That doesn't apply to the SBA review process, since the SBA review process happens after you begin the formal rulemaking process. The rules are a little different. And again, we're looking at those cost benefit analysis and the fiscal impact, trying to get those finalized. And the real thing, the real big piece here in terms of speed and moving through that process quickly is that the language matches. So if you're going to change your language between those two review processes, you should expect that it may take just a little longer, and certainly encourage you to get ahead of that by letting us know as soon as you know that you're going to change your language. So people ask us a lot, how can I get through your process easily, quickly, effectively, and how do I avoid getting emails from Patrick? So we've put together what we think are the rules to live by here. The first one is be prepared to talk about this. Talk about the rule with us. And these conversations are most productive, we find, when they include, depending on how your agency is structured and how resourced you are, when it includes both the subject matter experts on the rule, your program people or similar individuals, as well as your lawyers doing the drafting and managing the process, right? We want to connect those two sides of the process. Sometimes our questions are legal, sometimes they're policy, sometimes it's the intersection of both of those things. But one thing to know here, Patrick, when he receives a rule, he's usually firing off an email in the first day or two to agencies to make sure that we begin that process. And he'll usually he at least takes a cursory look through the language to do an initial high-level issue spotting to see if there's anything that we need to touch on at high level. And we'll begin having conversations with the governor's office at that time as well. The second thing is here, don't bite off more than you can chew. And so often what we see is larger rulemaking projects take longer. And that's, I know that's not a surprise, but the more that you try to tackle in one rulemaking, the slower that generally goes. And the reason for that is really twofold. One, obviously it's more complex because you have a lot of different topics in your rule. The other part of that is there's sort of an access cost to picking up a rule. And when we're having a back and forth about a rule, either from your side or our side, and we may pose questions or comments, when you have to pick a big rule back up, this is just a practical consideration. It takes more time to re-familiarize yourself with the rule, to reorient yourself. What was I thinking? What was I worried about? What were our concerns? What are the conversations we had? And so what we see in practice is that typically slows rules down, and it usually leads to larger gaps in time, usually from the agency's perspective in terms of when we send comments to the time that an agency has an opportunity to fully go through those comments and get back to us. And so what we try to encourage agencies to do and are encouraging agencies to think about is breaking your rules into smaller portions, really chunk those rules out into logical components if you can, and particularly if you have a higher priority aspect of your rule. So for example, if something has changed in federal or state law that you need to be compliant with by a certain date, we would encourage you to run that as a separate rule. And those rules typically move pretty quickly. They're usually more straightforward. They're usually pretty simple, and they can breeze through the process. I think the fastest I've ever seen somebody do the rulemaking process is 3 to 4 months from start to finish. Obviously, that takes a lot of preparation and due diligence to get there, but it is possible to move through quickly if you need to, and we will try to accommodate that as we can. The other thing here is don't reinvent the wheel. And so there can be a tendency to want to repeal and replace older provisions of your rules that have either become stale or that have just not been touched in a long time. And there's obviously a time and a place to do that, right? At some point, your rules are antiquated and you need to pick them up, and it's just more productive to take a wholesale repeal and replace. But similar to the "don't bite off too much" comment, it's a much bigger task. It's a much bigger lift to do that. And we find that across the agencies that have attempted that and that we have worked with, it tends to be a challenge, and it will go very slowly. And so we encourage agencies, unless you have a really good reason to do that, to try to stick to the language you have and adapt that language to make that language work. And I think looking at that from the cost benefit side of the equation, from the, we want to maximize benefits and minimize burdens, and that the repeal and replace of a rule wholesale has its own unique impact on regulated parties, because as soon as you change all of that language, regardless of how sophisticated the party is, and obviously it's a higher burden for less sophisticated parties, there's an onus now on those parties to learn how to comply with your rules. Remember to learn what's new, to learn what the new rules are requiring and how that differs from what was there before. And that can be very challenging, obviously, and it can obviously impose lots of transaction costs to get into compliance and ensure that you remain in compliance. And then for those small business owners and individuals who may be regulated by your rule, it becomes a very, very challenging task depending on the depth of your regulatory framework and the length of your regulatory framework. So it's, we encourage agencies to take that into account as they're making that decision. But obviously there are times when you need to do that. And so when you do that, one thing that we have recommended to a lot of agencies to consider when they do this is look at hiring or engaging outside resources or special resources to focus on your big rule efforts, whether that's a repeal and replace or just a large wholesale project that you may have. And we see this as a challenge in large agencies and small agencies alike. And so by hiring outside resources, it gives you that ability to keep doing your day job day to day. We all feel the press, certainly right now. I'm sure a lot of us are pinched by the legislative session, and that just detracts from the time and resources that we have available to spend on those other ongoing projects that we may have, like a large rule. So consider that as you're thinking about that. Let us know if you're thinking about that. We'll help grease the skids with our friends in the budget agency and see if we can unlock the resources you might need to do that if you need that. Getting into a little more particular comments on tips for getting through the process. One of the biggest hangups for an agency can be whether you've identified upfront what's new. What are the new requirements in your rule, right? One of the clearest ways to do this is through a red line, right? Similar to how we do legislation, and strike throughs and bolded language to show what's being removed from existing requirements and what's being added. The reason for that is it just helps you be able to tell from our perspective and triage what we should spend our time focusing on, what may really be imposing an impact, and what is the existing state. Because when we go through, as Patrick will talk through in the cost benefit analysis, when we're thinking about a rule change, the existing state is ignored for purposes of the costs that a rule might implement. It's only that increment from where we are to where we're going. The other thing is to check your legal authority. Obviously, the Attorney General's office spends a lot of time thinking about this. We do not do this comprehensively, but there are times when we run across situations where agencies, where we think maybe they're pushing the envelope on their regulatory authority, or maybe, depending on whether they intersect with federal programs and otherwise. And so, make sure that you're considering that, giving that due thought. And if you have concerns about that, come talk to us. Often there are other ways to accomplish the same objectives that you're trying to accomplish within the regulatory authority you have, but may just require a little creative thinking in how to get there. Another important part of the process is seek input from your interested parties, from your regulated stakeholders early and often, to the extent that you know who they are and that you have an ability to engage with them. That helps inform the rulemaking process. We see that agencies who do that tend to be more successful and have less pushback on their rules. And it also helps inform that cost benefit analysis. How we think through that also helps as we think about calibrating particular regulatory requirements in a way that's least intrusive to those regulated parties. One thing you've probably heard from Patrick a lot is avoid duplication of statutory and federal law in your rules. I know there's a temptation sometimes to want to be comprehensive in your regulations, but there's a couple challenges that come from that. One, when we duplicate statute in our regulations, when those statutes change in the future, there's then a need to go back and update your rule again to match that changed statutory language. And often agencies are not equipped to monitor that religiously and stay on top of that as quickly as they need to. The most extreme example I can think of is from my days prior to this when I did campaign finance law. And I was advising a client on how to comply with Illinois law, and the Illinois election board had not replaced their rules in over 10 years, despite the fact that the entire statutory framework had been repealed and replaced since then. And so the two did not even speak to each other whatsoever. It's an extreme example, but it can happen in small incremental ways across the board. The other part of that is what often happens is when you restate that statutory language, there's a tendency to want to paraphrase what the statute says to maybe make it harmonize with the other language you have in your rule. And the result can be that sometimes you end up changing the statutory requirement in a way that you did not intend, or you introduce an ambiguity that really creates a gap between what the statute says and what you think it says and how it could be interpreted. And so we really try to dissuade agencies from going down that path. You've probably heard from Patrick on including mandatory requirements that you're going to include in forms or that are in your policies. We'll touch on that a little bit in more depth next. And then, we're always available to talk with you beforehand at any point in your process, if you'd like. Patrick and I try to make ourselves available as much as possible. And particularly on your larger rules, as you're thinking about taking on a large project, we're happy to brainstorm with you. Not necessarily go through the process of evaluating the substance of the rule at that point, but help you plan out how you might best present that to us, what kinds of things you might want to think about, et cetera. All right, so how long does it take to get through the OMB review process? We've been keeping track of this for several years now. Patrick hounds me constantly if I am holding the process up and bottlenecking the process because I haven't approved a rule and it's impacting the metrics. So You can see here that what we've presented is on the left-hand side, you can see the total number of rules that agencies have submitted for us for consideration. You'll see that 2022 is a particularly heavy year for us. Patrick was spending a lot of time on that and did a lot of work in the rule space over the last year. And you can see that 25% of our rules right now, we're approving them in under 10 days. That's a significant improvement from where we were. And the real metric that we watch is the 75% of rules in 60 days. That's sort of our baseline that we hope to achieve with every rule, knowing that we'll approve many of them faster than that. But we try not to let the bulk of them get beyond 75 or beyond 60 days. You can see that really shifted there in 18 and 19 as we move forward into 22. And the real change there is that at OMB, we added resources to help with the rule review process. We hired Patrick, and he's been a tremendous asset to us. He's been able to spend a good deal of his time on this process and keep us on track so that we are not held up by some of those, the normal course of business that comes up throughout the year, session, budgets, et cetera, for OMB and SPA. And so you'll see that we've consistently improved those metrics, and we will continue to work towards them. So now I want to shift to our second topic. Really, this is sort of a topic that comes up a lot. Try to frame the question here in terms of what are the specific questions that come up, but at a high level, the question is what's a rule, right? And what's a rule versus what is maybe an advisory, best practice from your agency, or just an internal policy. So some of the common questions that come up, what must be in a regulation and what can be in an agency policy, or what can be in a form, or what can be in a manual. And when we think about this, we're thinking about requirements, right? What kind of mandatory requirements can be in those locations? Why isn't the agency policy enough? Often agencies will tell us, well, we're doing this by policy, but we don't have it in our rule. And so that leads to conversations about whether or not the policy is adequate. Sometimes agencies will embed requirements into their forms, and so their rules will touch on these topics in a general way, but they will include very specific requirements in forms. And so that can become a challenge as well. And then, as we touched on, can the statute be repeated in the rule? It's not comprehensive, doesn't tell people everything they need to know. There's obviously, concerns that agencies, lots of you have, in trying to be as clear as you can to your stakeholders about how to comply with the regulatory framework that you have. So for our purposes, our starting point for thinking about these questions is two places. It's the statute, the Administrative Rules and Procedures Act. As the Attorney General's office laid out, it gives the definition of what is a rule. And case law has expanded on this definition quite a bit. The Indiana Court of Appeals and the Indiana Supreme Court have grappled with this question more than once and have given us some more guidance on how to think about those questions. So we'll turn first to the statute. I won't reread it, as the AG's office covered this, but the takeaway here is I think the most of the game lies in sub-bullet 1 there, which is it has the effect of law. And that gets to, what do you intend your regulated parties to do with the information you're giving them? Is it something you're requiring them to do, or is it simply advisory? When you look at case law, I think what you'll find is that from the perspective of the courts, they interpret that effective law to mean that it's something that is mandatory. So you see here on the bottom in Ward v. Carter, a couple statements here, but they equate a regulation as something that articulates binding standards of conduct, or something that is a coercive mechanism or wields coercive power. I think at the end of the day, it's something that's mandatory. It's something that you intend regulated parties to comply with. And that if they don't, it will lead to an enforcement action from your agency. It will lead to a denial of benefits, a denial of some certification, something like that. There's some benefit or some consequence that will flow from non-compliance with that requirement. If that's the case, it has to be in a rule. You can see here at the top in Villegas v. Silverman, the Court of Appeals sort of laid out a 4-part articulation of the elements of the rule. There you can see each of the important aspects underlined there. It's something that has general applicability, right? So this is different from an enforcement action where you're applying a particular rule or statute to an individual stakeholder. It's something that's applied prospectively, right? So it's a policy you're putting in place to guide future conduct. It's something that has the effect of law, as we touched on, and it's something that affects substantive rights. That goes to that mandatory aspect of the rule. If there's a punishment attached to it, if there's a loss of a benefit attached to it, if somebody's not going to get something, or they're going to face consequences as a result of not complying with whatever you're articulating, it's affecting their substantive rights. And so why is that, right? Why is it that, a policy doesn't do that work for us? I think the Attorney General's office touched on this in part, but really it starts with the fact that the power to make rules flows from the General Assembly, right? An agency only has rulemaking authority, number one, if the General Assembly has granted that power to the agency. And then two, the General Assembly has outlined a very specific process, as we've spent the morning talking about, for how to adopt things that are considered rules. And I think you can think of this a little bit like due process, right? What the legislature is saying is we want you to go through a certain public process that has notice to the public, provides an opportunity for feedback and input, similar really to the legislative process, right? Where we have an opportunity for regulated parties to breathe into what we're proposing are the rules. And if you don't follow that process, then you can't have the effect of law. You cannot be the rule that or the proposal, the requirement that you're trying to put forth, it can't be enforced against those parties. And so you'll see in a number of cases, Villegas is one example where the courts have said, you have to follow the process, and that the public participation in the rulemaking process is a very important aspect of the Administrative Rules and Procedure Act. And what you'll see is that the courts will not enforce those rules without that process when challenged. So obviously not every action, not every rule gets challenged, or every policy that may otherwise need to be a rule. But when they do, and when they make it to the courts are pretty consistent in saying to be a rule, you have to go through the process. So a couple examples here, one in Villegas and another one involving the apartment, involving IDEM. And then here at the bottom, we wanted to highlight a couple of examples of alternatives, right? So in addition to in addition to rules, there are other ways that agencies attempt to go after this. One might be forms, right? You could put a requirement in a form, which might be similar to a written policy, or you may have a written policy in your agency that you intend to, that you treat like a rule. In Villegas, they said that's not enough. It could be an oral policy where really it's just sort of a standard of practice that's developed in your agency, but in reality, that requirement has never gone through the rulemaking process. In the Indiana Kentucky Electric Corp case involving IDEM, there the court found that's not adequate. You have to go through the rulemaking process. And then another one to highlight here, this one hasn't come up in Indiana specifically, but it's come up before the U.S. Supreme Court involving the city of Los Angeles, and it has to do with imposing certain mandatory requirements through contract. Now, this isn't like a service or a vendor contract. It's a contract that particular individuals or companies are required to sign to do business in a particular area. So I'd encourage you to look at that case. We don't necessarily see that issue here too often, and again, it hasn't come up in the courts, but I think it's something to be aware of and helps provide a broader context for how to think about this issue. This case, interestingly, was also cited by the Indiana Supreme Court, though they didn't really pontificate on this specific facts and whether it applied in Indiana. So some examples of what you should include in a rule and how we think about this question. At a general level, it's requirements that must be met. It's something that's mandatory. As I said, if you're going to hold it against somebody, you should put it in a rule. If it's going to be the basis for denying an application or a permit, it's going to be the basis for a violation of an enforcement action. And then at a more specific level, if you're, what particularly might that be? Well, information that you're requiring in an application, right? So if you, I'll take Dan Shackle and the BMV, they require your residency. If you don't have that in a rule, you can't hold it against somebody if they don't give it to you. Similarly, if you want to know somebody's name, you have to require that in the rule. The others are documents required to prove identification. So that's the BMV example. Equipment that might be required to carry out a particular activity. That's going to be at a number of our regulatory agencies. Training standards that you might require. Obviously, a number of you have training standards for the groups that you regulate. If you're going to require it, if it's mandatory and it's otherwise going to prevent a certification or it's going to lead to an adverse action, it should be in a rule. And the other is fees and fines. I think everyone's pretty familiar with this. One thing that that I want to note here, though, is that it doesn't have to be the exact amount of the fee or the fine. I mean, generally, that's probably the best practice. That's the clearest way to do it. But there are circumstances where the fee or fine that you have may be one that needs to change over time. And there are some cases that support this concept in other areas where you can use a formula if it provides enough particularity and enough certainty for that fee or fine to be calculated on the factors that are identified and the variables that are identified in the regulation. So if you can pull it together from what's defined in the rule, you're probably satisfying that requirement. It's just about whether a regulated party would have certainty, whether they could ascertain what that fee is or how it would be calculated. So a couple examples of maybe how these things play together, and I'll pick on Dan Shackle again here with BMV. So thinking about statutes, regulations, and manuals, and these examples are really geared more towards the question of the comprehensive nature of regulations and how we think about that when agencies ask us that question. So you have a statute that says, among other things, to get an ID card from the BMV, you have to be an Indiana resident. In BMV's rules, they specify what specifically you have to provide, what kind of documents you need to provide to meet that requirement. And then in their manual, they bring it all together. It's a comprehensive statement in plain language, tying that all together. And we think that's the appropriate place to do that, is in your manuals. Another example from DNR. So obviously, statute lays out the requirements for hunting licenses. Well, DNR has the authority to impose some additional requirements on that. And so you can see that they've done that in rule. So they want you to complete a hunter training course as part of their rules. And then they bring that all together in their hunting manual where they tie all of these requirements together. I think, as you think about these examples, there could be another insert here between regulation and manual, or your agency might have a policy. We couldn't find an example that we thought worked for this presentation, but your policy might elaborate more on your regulation and your statute in a way that's not intended to impose new requirements, but may help guide how someone should think about complying with that, processes, those kinds of things, how your agency might implement those aspects. So we pulled this together in what we hope is a helpful table to compare and contrast the four different kinds of documents that we think we're talking about here. So statutes, rules, policies, and manuals, working from left to right, really working from strongest law to not. So you can see in terms of purpose, obviously statutes are there to tell us what the law is, and they come from the General Assembly. Rules are intended to expand on that, right? So they're there to fill in the gaps, as the Attorney General's office was talking about. You're really filling in those interstitial areas where the legislature has left discretion to us as administrative agencies to bring more particularity to whatever requirements or schemes that they have put in place. Your policy is there to explain and clarify some of those specific requirements, though not impose new mandates. And a manual is there to synthesize it all, bring it together, right? It's a how-to manual. How should I comply in this particular area, right? And so those can be very broad. They can be narrow to particular stakeholder groups. I think it depends on what the purpose is and who you're trying to communicate with. In terms of legal enforceability, we think the first two are legally enforceable. As the courts have said, the last two are not, because they haven't gone through the rulemaking process. They haven't had that legislative due process that the legislature has articulated. And then you can see here, just in terms of thinking through some of the different other elements of those in terms of style, their comprehensive nature, and what it takes to adopt them. So with that, I'm going to turn it over to Patrick to talk about cost benefit analysis. And then after that, we'll go to question and answer.
All right, so we're here to the part that everyone is waiting for, which is the last speaker. Get to end. So the cost benefit, as Justin said, this is another place. This is really where OMB spends a lot of time working with agencies, and I want to start kind of high level and go more detailed. But what is the purpose of the cost benefit analysis? And this is really to document what is the impact of your rule. And the goal of this is to justify anything that we're doing through regulation, to demonstrate that there's a good basis for it, that the benefits exceed the cost. And when you're working with OMB, a lot of our focus is going to be making sure it's accurate. And then beyond that, making sure that we're doing the best that we can to minimize the negative impacts while maximizing the benefits. So the steps, and we're going to talk about each of these steps in turn. And I'm going to have example language in a lot of these places that's pulled directly or slightly paraphrased from cost benefits that agencies have submitted. So you can see examples of what people are doing. If you want more detailed examples or want to see full, write-ups that other agencies have done, we're happy to provide that. There's a lot of good models out there. The first step is to identify each new requirement in your proposed rule. Justin touched on that. We're going to hit it again. Once you've done that, identify who are the impacted parties by the rule. Then we move to, for each new requirement, what are the benefits? Then for each new requirement, what are the costs? We get to our math step, where you have to aggregate the benefits and cost for each requirement, and then for the total rule. Step 6, explore mitigation options, really ways to reduce the costs that are imposed while still achieving our benefit. And then step 7, which Justin also mentioned, is seeking input from affected parties. So the first step, and this is, as Justin said, this is really where we see a lot of, for rules that take a long time, this is where we see the biggest slowdown, is figuring out everything in this regulation that's changing from current requirements. And so part of the OMB process is when you submit a rule to us, to identify everything that your rule is changing. Again, everything that's changing from current requirements. And Justin mentioned the repeal and replace and the challenges there. That can be a challenge for repeal and replace because you have to kind of crosswalk your rule that's new to everything that's in existing code. So it's something to consider. Red lines are an awesome way, really, really awesome, strongly encouraged. There are alternatives to red lines if your agency has a alternative or better way to do it. Also, for really large rules, lists or tables can be really helpful, where you just create a list, you create a table and just say, here's everything we're changing and why. Something to keep in mind as you're identifying changes, there's kind of two aspects. One is a change from existing regulation, but something could be changing from existing regulation, but it's not a new requirement imposed by the regulation itself. And so we see this with agencies, and it's really helpful if you annotate those. And so examples are, is something's changed in statute. And so your regulation is being changed to reflect that. It's a change in the regulation, but it's not a change in the requirement because of the regulation. And so those kind of get exempted out. An example from Homeland Security, we're working with them. They took their program from voluntary certification to mandatory. And we're like, whoa, that seems like a pretty big change. And it's like, oh, this was required by statute. Okay, well, provide us the statute. And then that kind of flows out of the analysis because it's not being imposed by the regulation. So that can come from statutes, other regulations, federal regulations, court orders, national compacts, something like that. So if there's another source for the requirement, annotate that, point us to it, and it basically drops out of your cost benefit analysis. Again, this is where tables, lists can be really helpful, or annotations in the text itself. All right, so we've identified all the changes. And again, that can be a really big step. Our next step is identifying who are the impacted parties. And there's several reasons for this. You know, principally the number of impacted parties serves as the multiplier for your cost and benefits. So we need to know who's impacted. And as you're doing this, you want to think broadly. And this is considering everybody affected by the rule, not just necessarily the regulated persons. And get into that a little bit more. And also as part of this, you're excluding people from our analysis that are already in compliance. So if you're imposing a requirement, but 50% of people are already doing it, then they get excluded from the cost benefit because there's really no change in their behavior. So in determining your number of impacted parties, there's a lot of different sources, agency records, calculations, research, estimates. We've got some examples. Sometimes you just know. PLA did a rule on beauty culture professionals, beauty culture schools, and they know here's how many we license. That's a pretty darn specific number. Sometimes you can calculate. Egg Board was changing packaging requirements. They knew how many entities that they regulate and oversee, and they say we're going to back out from that number entities that aren't affected. So you can kind of calculate from what you know. Sometimes you can estimate. You don't know exactly. So Homeland Security is changing the building code requirements. They don't know how many permits there are, but we can look to the census. And the census data is going to give us a pretty good estimate of how many building permits we can expect in Indiana. The health department's working on a rule now, changing requirements for septic systems. Those permits are issued by the local health departments. So they did a survey of the local health departments. And they took the responses and then did some extrapolations out. Based on the responses we got, we can expect that we're going to have this number of septic permits a year. So, you know, there's a variety of ways that you can get at the number of impacted parties. Once we've identified what's changing and who's impacted, we move on to benefits. And this is an area where agencies, in our experience, typically struggle. Not because there aren't benefits, but just because we haven't necessarily been very good at explaining what the benefits are. And the way we look at this is benefits answer the why. Why are you here? Why are we doing this? Why is this regulation in place? And, you know, it's really the reason, how did this come to your attention? Why are you doing this? That's probably the benefit of whatever your regulation is. If we want to go back to Econ 101 in college, benefits are your positive externalities of the rule. So when you're thinking about the benefits, you're going to think about what are the benefits, who gets the benefit, and how to calculate them. And who gets the benefit is very interesting because it's usually someone other than your regulated group. Example, we're regulating pollution. It's not the polluters that are getting the benefit, it's society at large. In the case of the Egg Board with packaging for eggs, it's not the packagers necessarily that get the benefit, it's society at large that's going to benefit. So when you're thinking benefits, really think broad, think big. So how do you calculate that? We're going to get a little circular here. You calculate the same way you calculate cost, but often benefits are less certain. And that's just because of the nature of the benefit. That they can be intangible and less concrete. For example, trying to regulate to reduce pollution. Why? It leads to better health, lower diabetes, lower heart, whatever it may be. That's a little bit more intangible. Egg Board, you're trying to prevent salmonella outbreaks. Okay. Typically with these benefits, then you're going to be using some sort of assumptions or estimates. We're trying to reduce pollution to improve health outcomes. Here's a research study that said that the chemical or the pollutant that we're trying to regulate leads to these outcomes. We can take that study, apply it to Indiana. What's our experience? What's the probability that reducing the pollution this amount is going to produce these benefits? The egg board with regulating packaging for eggs. How frequent are salmonella outbreaks? How can we trace it back to this? So a lot of times with benefits, we encourage agencies to look at research studies, look at other information out there. A frequent question we get is, can you put a value on, or can you put a price on safety or health or human life? And the answer is yes. That's what we do. It's actually what we're required to do. And there's some really good ways to do that, but a lot of that's contained in research. And we can help point you to those sorts of resources. So some examples, and again, thinking about why did this rule come up? Why are we here? Health. There's a research study that says that people with elevated blood levels have increased healthcare cost and a loss in lifetime earnings. Well, damn, that's important. We should do something. Egg board. There were 8 cases of salmonella outbreaks in Indiana traced to backyard poultry flocks. Well, that's a problem. We should probably do something. IURC. There was a gas pipeline explosion in Massachusetts that caused $1 billion of damage. We have similar circumstances in Indiana. Well, we should probably do something about that. Now, in the case of this, you can't just say $1 billion. It's, how analogous are the situations? How likely is it that we're to have an incident like that? How likely is it that our regulation is going to reduce that risk? So there's some levels of estimates and assumptions that go on top of that. IDEM, this is from operational experience of your program. They realized they're having a problem that people that are on military deployment were unable to meet certain deadlines. Like you can't retake a test if you're in Iraq or Afghanistan. Oh, well, again, that's a problem. We should do something about that. Insurance. This is an interesting example. We're part of a national compact that requires us all to have the same standards across the states. If we don't do that, then all of our insurers can be audited by all the different states. So again, that's a problem. We should do something about that. And that's what you should think of after the benefit. It's like, oh, that's a problem. We should do something. That's why we're here. Which leads us to step 4. So we've got our problem. We know we need to do something. Step 4, the cost. What does it take to achieve that benefit? And similar to benefits, we're asking the same questions. What is the cost? Who bears the cost and how to calculate it? The cost is really the burden that's imposed by your regulation. It's what does it take to comply with the rule? Going back to college, Econ 101, it's the negative externality of the rule. Who bears the cost? This is typically going to be your regulated party. Your rule is requiring them to do something. So they are probably the primary bearer of the cost. But there are cases where others are also impacted. And so costs can also impact anyone who must change their behavior in order to interact with the regulated parties. How do we calculate cost? Yes, we are circular. You calculate it the same way you calculate benefits, but costs are often more certain and ascertainable, and they're often more concrete and tangible. A lot of this is because you know what you are imposing by the rule. You know who you are imposing it on and what they have to do. So it's a lot easier to determine the cost. So you may require some assumptions and estimates in order to calculate that cost, but they should really be evident from your rule and logically flow from it. Again, you know what you're requiring people to do and who you're requiring to do it. So some ways that you can look at estimating cost. Surveys of regulated parties are a great way, or other things like that to seek their input. Like, we want you to do this. How much are you going to have to change your behaviors, and what will it take you to do that? And importantly here, you get to exclude cost for parties that are already in compliance. So what are some ways that we look at this? And here are some examples that we've seen. So the state chemist, they want to require people to have a new document management tracking system. They say, look, we know there's 300 regulated entities that are in the public sphere that are going to be impacted by this. We regularly inspect them. We do regular enforcement actions, and we can say that 80% of them already meet the requirements of this rule. So 80% of those 300 are excluded from your cost calculation because they're already in compliance. They don't have to change anything. Homeland Security, similar type situation. They wanted to change the standards for EMS and ambulances. They have a system of regional managers. They regularly inspect the entities that they oversee. Also, anytime there's a new ambulance, someone has to be there. So they've got a pretty good idea of how many ambulances that are out and existing now are in compliance with their requirements. So enforcement records can be a great way to gauge your existing compliance and reduce your cost. You can do surveys. DOC was changing the requirements for juvenile detention facilities. They know how many there are. There's 19. They sent them a packet and said, here are all the new requirements we're thinking of imposing. How many of them are you already in compliance with? How many of those would require you guys to impose or to bear some sort of fiscal burden? So that's a great way. Can also use surveys plus internet research. So it's another Dan Shackle call out. I think he wanted to kill us after this. But the BMV wanted to add a requirement that driver training education cars have a second rear view mirror. And we're like, that's great. How many cars are going to have to add this? Dan Shackle, maybe not willingly, but with a smile, did a survey of the driver training schools, found out that there are 5 cars in Indiana that are going to have to add a rear view mirror. Did some internet research for $14 on Amazon. You can buy the mirror, you can be in compliance. So we're imposing a cost of $70. So thank you, Dan. All right, which brings us to our math step. So we've identified the parties, we've identified the benefits, we've identified the cost. Now we have to do the math. And so a couple of points here. For each new requirement that's imposed in your rule, and this is done at the requirement level, you need to multiply the average cost that you're imposing by the number of impacted parties, excluding existing compliance. So sorry to throw in math. That's not why you went to law school. You need to do the same thing for benefits. You need to look at the benefits for each rule, each requirement that you're imposing. Once you've done that, then you need to, for each requirement, show that the benefits exceed the cost. And then you need to add up all of those net benefits for the total net benefit of the rule. One important note here is the benefits from one requirement cannot offset the cost of another. You know, they're logically all tied together, sure, but it's not like, hey, we're doing something really good here. Something totally unrelated imposes a bunch of cost. It doesn't work that way. Each one gets evaluated separately. Strongly encourage people to consider using a table to do this, because it can, if for a big rule with a lot of requirements, it can get pretty cumbersome to do this, and a table really makes it a lot easier and digestible. So an example of kind of tallying the cost and how to do this and taking out existing compliance. We have our friends at PLA. They're imposing a requirement for people that are going to do dry needling, physical therapists, that they have to take certain courses. This is new. It hasn't been imposed before. So they went and did a survey of their licensees. They found that 239 had already taken one course, which is kind of half of what they need to continue doing this in the future. There are 76 that have taken both courses. So then estimating the cost based on some internet research, looking around at what providers offer, we're looking at the cost to complete the training would be $600 to $1,000 for those 239, not counting travel or lodging. So we're looking at a total cost imposed estimate of $239,000 for those existing licensed physical therapists who want to continue doing dry needling. Important to note, we don't include the 76 licensees who have already done all the required training. So they wouldn't have to do anything new. Again, since they're already in compliance, we're not imposing a new cost on them. And looking at how do we weigh, because this tallying is also the weighing, showing the benefits exceed. So what does that look like? Going back to health and lead. Here's their study. There's a study out of Texas that found that kids with elevated blood levels had lifetime problems, and that the societal cost per child was $10,813. There's also lifetime learning loss. There's criminality, but those costs include medical intervention, ADD, parental time off to deal with the health problems, special education cost, the lost earnings. So there's a lot rolled up into there. There's also a bunch of things that they didn't include, but they could have: pain and suffering, adult medical care, the increased criminality. So using this research that's out there, using a conservative estimate, we're looking at the benefit of this rule would be 20.9 million in year one. Which is a pretty good reason to do it. What's the cost to get there? Most of the cost that they're imposing is going to be on local health departments for increased testing and case management. So they went and looked at what the local health departments are going to have to do in terms of adding staff, adding testing, paying for all these things. And they project a 10-year cost of 120 million. So really high cost. And the reason we included this is because it has a really high cost, but the benefits are even higher. So there's kind of this misconception that rules can't get through OMB if they impose a cost, which is not really accurate. That what we need to see is that the benefits really exceed the cost. So I think this is probably the largest cost we've seen in a rule, but it also had the largest benefit. Another example, the Egg Board, we've talked a lot about them. We mentioned that the CDC had 8 cases of salmonella outbreaks in Indiana that were traced to backyard poultry flocks. There's a problem when these outbreaks happen, because if they're using recycled egg cartons, you can't tell where the outbreak came from. So somebody might get sick. You're trying to trace it back. You don't know. And so that makes it a problem to mitigate and stop the infection from getting other people infected. So we've got kind of a consumer safety benefit and a product traceability benefit, so we can mitigate it. What's the cost? And I'm not going to walk you through this, but if you look at the slide, that the Egg Board really did a fantastic job of kind of walking through each step of the cost. So they looked at how many registrants they have, looking at how many eggs they're going to distribute a year. Then in terms of our cost, we're going to assume that eggs are put in cartons of 1 dozen. They estimated the cost per carton based on internet research, kind of what's the cost per carton. You purchase cartons in a 100 carton pack. So, what's the actual purchasing that these people are going to have to do? So then taking the average cost of a carton, total number of eggs, dividing by the cartons, what's this actually going to impose on our small kind of poultry producers? And walking through each of those steps, they come up with a cost of $438 per producer, $60,000 total. So pretty awesome way to walk through all the steps and how to use assumptions. Mentioned tables. Tables are awesome. Tables are your friend because they're our friend. But tables can be really helpful to summarize. Some agencies, FSSA, Health, and Homeland Security in particular, have some really good examples of tables if you want to get an example sent. We just kind of mocked one up here, but a table can be really awesome when you have a lot of requirements, because you just do requirement 1, requirement 2, and then for each one, you can walk through the cost and benefits imposed. They can be really helpful too, because not every time your impacted parties are going to be the same for each requirement. And so tables can help with that. your benefits and things like that. Your existing compliance can vary by requirement. So it's just really helpful with the table that you lay it all out. It's easy for us, it makes the review process go a lot smoother. So now, after you want to kill yourself, why did I do this? We move to mitigation. So how can we reduce the cost that we've now numbed our brain calculating? And so this is a big emphasis that we work with a lot of agencies on. So we've got the benefit. We know why we're doing this. There's a compelling reason. We've identified a way to solve it. And then we'll talk with you, are there ways to reduce that cost without sacrificing the benefit, but are there ways to reduce the cost of imposing the burden? And so a number of things we're going to kind of walk through some examples. But there's a number of different techniques we've utilized with agencies to do this. And we are very happy to assist with brainstorming on mitigation. So some of the things that we've seen, commonly used techniques, grandfathering. Not going to ask for a show of hands, but a lot of you have probably heard us ask about grandfathering. So if we're changing requirements, then it's going to be really burdensome for people that are already operating under the existing requirements to change. Maybe we grandfather them. Health, in this case, they're changing the requirements for septic systems. It's really hard for someone with a septic system to dig it all up and put in an entirely new one. And that's a pretty big cost. So we're looking at grandfathering them. So, in this case, the new rules we're putting in place don't apply to someone with an existing system unless we're replacing a part. A little bit, kind of the next layer down from grandfathering is kind of a safe harbor. So not quite a blanket grandfathering, but we're going to do a safe harbor for existing people if you follow some steps. So I know a lot of you are concerned about your boreal chorus frogs. And so DNR changed the requirements. Turns out that I think they're either native or non-native to Indiana, I can't remember, but it changed the standards. And so you couldn't possess them anymore. They recognize that there are people out there, probably many of you in the audience, that have a boreal chorus frog and you're concerned. And so rather than just grandfathering you, we're going to create a safe harbor. So if you have your boreal chorus frog, this requirement's coming in place, then, report to us by, whatever date. You're essentially grandfathered, but you have to take those extra steps to get the grandfathering. So this is a safe harbor. Delayed enforcement. We got a lot of examples from DNR here. Delayed enforcement, we'll explore this with a number of agencies. DNR, they're changing the standards for traps that hunters can use. And that can be a problem because if you're a hunting store, you have a bunch of traps, which are legal under the current rule. Once the new rule comes into place, all those traps are now illegal. We've now devalued your inventory. That's a pretty big hit. And so what they did was effectively had like a year delayed enforcement of this provision to let those stores change your purchasing practices, modify your inventory, modify your conduct, but giving them time to comply. Another example with invasive species, similar type thing out of DNR. We've got a problem with certain species. We need to put them on the invasive species list. We're going to limit what you can do with them. In this case, we're going to limit, selling, offering for sale, gifting, transporting, or introducing it. So we don't want people to introduce it anymore. We're going to make that effective immediately. That's pretty easy to comply with. But again, for like the context of nurseries and garden stores that may have these plants in their current inventory, we're not going to essentially devalue your inventory immediately, make it so you have a pretty high financial loss. So requirements, the first and second, selling or transporting, you get a year to comply with that. You can't introduce a species anymore, but you get a year to comply with the selling and transporting. Another DNR example, we'll explore ways to make rules easier to comply with. So in this case, DNR wanted to put a speed zone on a river up in Fort Wayne. Kind of not quite a no wake, but slow you down in certain areas for safety. The original rule said that the speed zone was identified by coordinates. So all of your boaters would have to know in their mind, oh, I've crossed the coordinate. I now have to slow down. That's kind of a big burden to put on the individual boaters to know that. So we worked with them, and then they actually worked with the city of Fort Wayne. So it got changed to, we're going to put signage. So we're going to have a speed zone, but kind of like roads, there's going to have to be signs at the beginning of the speed zone so that boaters know. So examples like this, looking at what's the practical impact that people are going to do and how can we modify that. And really important here in terms of considering human behavior. And there's a great book. It's not actually by Richard Epstein. That's my fault. It's Richard Thaler and Cass Sunstein. So I kind of amalgamated them. But they have a book, Nudge. It's actually kind of about regulatory action. And it's actually entertaining. But they talk about how rather than kind of standing in the middle of a river and saying stop, taking that current that people are doing and tweaking it. Are there ways that we can nudge them towards the behavior we want rather than just trying to stop a huge flow? And so there's very effective ways that they have that agencies can consider. Our kind of last example with minimizing cost is helping regulated parties with the transition. And Justin mentioned that there's a burden to any regulated party when there's new requirements. So how can we ease that? And DNR and BOA are really great at this, that they have a pretty discrete community that they regulate. They've got regular communication to them. There's newsletters, there's announcements, people know where to look. Every time something new comes out, they're putting it out there. And they're communicating to all the people and helping them with assistance. So there's a lot of times we'll ask agencies about what they're doing to help people transition. So now if you really want to kill yourself, step 7 is seeking a second opinion, getting input from regulated party. And Justin mentioned this. There's really a lot of benefits to getting input from affected parties before you come to OMB. The first and simplest one is we're going to ask you. If you've done it. And so it's great when you have. Some of the really good ones, though, are when you get the input from the regulated parties, it can validate the work that you've done. If the regulated parties are like, yep, we looked at what the agency proposed, we looked at their cost benefit, we're totes good. That makes our job really easy. A great example from IURC, they just changed the 811 know before you dig rules. It applies to really excavators and utilities. They got everybody in the room. They talked to them. I think Beth, correct me if I'm wrong, and Jeremy, I think you guys sent out a notice to 10,000 people as part of that. So they solicited input from 10,000 people. They all came back like, hey, we're totes good with this. We can do it. I think there are things you guys hadn't thought about. The rule got tweaked. By the time it came to us, everybody that was affected, positive and negative, totally on board. That was really easy. They can help you identify factors you missed. Also, and this is really important from kind of the small p political perspective, getting input from regulated parties really helps avoid surprises. So if you're doing something and regulated parties are going to be upset, going to come out at some stage. And it's really helpful that you let people know. You've worked with your ops director, you've worked with the governor's office, with OMB to prepare for that. There may be very compelling reasons we're doing it anyway, but it helps to be prepared for that pushback. Or maybe we want to reconsider some of the things we're doing. But it's really helpful from that small p political perspective to avoid surprises that you've talked to the regulated entities before you're submitting the language to us. Also, since we're in session, I think it's important to note that getting input from regulated parties, helping get kind of that governor's office response preparation plan can really help avoid legislative responses. If the regulated parties have been involved. They've had their input received. They understand why we're doing things, even if it's not necessarily what they want. They're far less likely to run to the legislature and get a reactive bill. And I think we see this every session, that there's a couple reactive bills because agencies are upset. So this is a great way to avoid it. Got a couple of examples here about agencies that have done a good job of this. DHS on the building code. They had subcommittees, they got everybody in, they had testimony, they had hearings, they had studies, had really kind of a sub rulemaking process before they did the rulemaking process. Gaming, similarly, with some of their new programs, they had a series of stakeholder meetings before they came to OMB and before they proposed the rule. So you had a series of stakeholder meetings, which they're discussed. You've rolled out the language. So by the time it gets to us, there shouldn't be any surprises. Everybody knows what it is. They've all had an input. And again, you're avoiding those surprises. You're avoiding the legislative response. And talked about IURC. IURC does a great job of that, of getting all the parties at the table before they bring regulations forward. So kind of concluding, we're OMB and we're here to help. You can always reach out to Justin, myself, Jess, who's awesome. If you know who she is, you might get a reward. We also have a lot of resources on our website. We have the overview of the process, links to the key documents like the FMCs. We're going to put up a kind of an expanded version of this presentation there. And then if you have the slides, you can go to the link. There's a Freakonomics podcast on the Nudge book, which is entertaining. It kind of condenses the book down. And if you're really excited and want to get the whole book and want to have a book club, we'll talk about that too. So thank you guys very much. Got questions too.
All right, I would like to, there is an opportunity if you have questions. I think we have all of our presenters. I'm not sure if George is still here or not, but all of our presenters still here. So any questions for OMB? I know we had some time with OAG, but all right. Well, that concludes our presentation and our seminar. How about another applause for everybody presented today? Thank you, OMB. It was excellent. Patrick and Justin. Look for this. We'll be hopefully doing this at least on an annual basis moving forward. And as changes happen, we will keep you informed.